Next case is Joan Pace Clark versus Publix Supermarket. Counsel, how much time do you want to reserve, if any?
If I could reserve 5 minutes, Your Honor, I'd
You got it.
Thank you. You all ready?
You may begin, sir.
Thank you, Your Honors. Good morning. My name is Randy Schimmel, Clinic May Police Court, and I represent the appellants in this matter, the plaintiffs in the lower court, Joan Pace Clark and her husband Dale. This is a case where we're appealing an order dismissing the plaintiff's claim for fraud on the court that was entered in the lower court. It's a slip and fall accident that occurred in December of 2000.
Let me ask you this, just to get myself oriented here. I think we probably understand the facts. What is our standard of review here?
It's abuse of discretion. And the standard at the lower court is that the defendant, Publix, had to prove by clear and convincing evidence that these plaintiffs have set forth consciously a conscious effort to defraud the court, to make a mockery of the trial court, or to deprive Publix of its right to defend this case. And they have to prove that. Publix has the burden of proving that at the trial court level by clear and convincing evidence.
This is a husband and wife?
Yes, sir.
If they proved it with regard to the wife, does the husband's claim go by the
I think it goes away. It's a derivative claim there, so I think it's why.
That's just a consortium claim anyway, isn't that? I mean,
Yes, sir. Yes, it's purely consortium.
Counsel, let me just amplify a little bit of what Judge Torpey was saying about abuse of discretion. To us, that means that no reasonable circuit judge anywhere in the state would have done that. And you've got quite a burden to overcome that.
I absolutely.
Particularly in view of the fact that there are surveillance pictures that show that this woman just wasn't being level with the court. And I can, I don't know how you get around that. I admire you for taking this case, but I mean, my gosh.
Well, Your Honor, with all due respect, I don't think that it's not that she was not being level with the court. I think that she just has a misrecollection of how this thing played out. If you look at the still.
Do you really want us to go back and let you try this case when you've got a surveillance camera that shows that the slip and fall wasn't what she described and didn't really do anything to her?
Well, that's part two of the case. I admit that I have a very tough burden of going in front of a jury.
I don't know how you can ever win a case like that when on the slip and fall when you got a surveillance camera that shows that it really wasn't a fall.
Well, the important thing is that it shows she did fall. There was a fall. It's just not the way that she described it in her deposition or the way that she recalls it. And there's no testimony in this case from any medical record from any doctor.
What other evidence do you have in the record that would indicate how she fell and the cause of the fall?
Well, we haven't gotten to the point where I just got into this case at the point.
Well, yeah, I know, but we've got to look at the record now. And so you said that she really can't remember, so she may not be a reliable witness, and we got a videotape that clearly shows what happened. And so what evidence do you have that would allow us to say, okay, well, there's a disputed issue of fact here and let the jury resolve it?
Well, the disputed issue of fact is I contend that the video actually shows a foreign substance on the floor. We have been provided with 13 still photographs.
Okay, other than the video, what evidence do you have in the record that can support your claim?
There will be evidence from.
I mean, if there's a summary judgment proceeding, you better get your evidence in at that time, isn't that right?
Yes, sir.
You can say, well, discovery's not complete, and use that as a argument to the trial judge. Look, summary judgment's not right here. We've got more discovery, but we have to look at the record here. The judgment was already entered here.
Yes, sir.
So what's in the record here?
This was not a summary judgment proceeding, though, Your Honor. This was a motion to dismiss for fraud.
Okay.
Well, the record was clear as far as the issue that we were in front of the court to adjudicate that day. But there is more discovery to be done before the summary judgment.
Okay. Excuse me about the summary judgment. What evidence do you have in the record that supports your claim other than the videotape?
That's all the discovery that had been done in the case at the time that the.
Did you ask the judge for a continuance of the evidentiary hearing in order to uncover more discovery? I don't mean you, but I mean did the plaintiff ask for it?
And I represented the plaintiff at the evidentiary hearing. But I did not
request for a continuance.
No, sir, because I thought that the record.
You're going to win.
I thought that the record was clear enough at the time as to the issue that we were before the court. We weren't there talking about the negligence.
Let me ask you this. You're talking about two issues when you're talking about essentially perjury. You're talking about
Yes, sir.
whether the testimony was false and whether the testimony is intentionally false. Whether there was some intent to defraud. And if I heard what you said earlier, you said that, well, she may have been mistaken about the substance of her testimony, but there was some insufficient evidence that she did it intentionally. Is that your argument?
Basically, that's it, Your Honor. This lady was very forthright during her deposition testimony in the case. She talked about it prior on the job interview.
She didn't say, I don't remember how the fall happened, I don't remember how I landed. I mean, she wasn't vague about it during her deposition. She gave a very specific kind of they drew out a very specific recollection from her, which was controverted by the video. So you acknowledge that at least as to the second issue in a perjury issue, whether the testimony was false in fact, you acknowledge that it was false in fact.
Oh, I don't think I can make any credible argument that she fell under her back. Absolutely not.
All right. So then the second issue is intent. Okay. And now the trial judge had an evidentiary hearing below.
Yes.
And isn't the issue of intent ordinarily a question of fact?
I think it is. Yes, sir.
Don't we really have to defer to the trial judge's finding on the intent issue?
Well, when you get to the point where it has to be by clear and convincing evidence to the trial court, I set forth part of the testimony.
We have criminal cases up here all the time when the burden of proof is beyond a reasonable doubt, and the case goes to the jury on the issue of intent, and the jury decides, the intent. And I submit to you that, when the issue is intent and the fact finder has heard evidence on that issue, those cases are overwhelmingly affirmed on appeal. And I mean, here we have a trial judge who is sitting in the position of the jury as a fact finder on the issue of intent. Why don't we? I mean, how can we tell the trial judge, you were wrong about that?
Because you have to look at the totality of the circumstances in this case. This is a lady who.
Well, he did that too, right? I mean, he was supposed to do that, or she, or whatever.
I'm sorry. The trial judge.
The trial judge looked at the total circumstances.
Yes. Yes. This is an event that took place, and that's why we think there was an abuse of discretion. Because
Counsel, I'll have to be very candid with you. In the 40 years or so I've been practicing law, I have never seen a more clear and convincing case than this. I mean, this woman claims she had this slip and fall and goes through this long parade about how she fell and all of this stuff. And the video camera, then she comes into this evidentiary hearing, and her testimony is just absolutely incredible. And it's just, there's all kinds of convincing evidence to me, at least, reading the record without even seeing her, that she was just making this claim up and trying to get some money out of it.
But the fact is, Your Honor, that she did fall in PUBLIX. And why would she make up a different way? And in fact, the trial judge put this in.
When you look at the videotape, the fall that she took would not have injured anybody. I don't believe it. I mean, it's just, we've got the video, we've got the still pictures of it. We don't have the video, but we got from the record, we've got the still pictures. And this woman wasn't injured in that fall. There's no way she could have been injured.
With all due respect, Your Honor, I believe that that's an issue that the jury should decide, and based on...
No, it's an issue that the judge had to decide, and in this particular case, Judge Alley decided against you. And I think Judge Alley was right, just looking at those pictures. We're not in a position where we can disagree with her, because the pictures back her up.
Did the doctors testify in this case?
No testimony from any doctors, Your Honor. And
so, going back to my prior question, this record is devoid of anything other than, maybe some of the interrogatories, your client's statements and the video, and that's basically it.
Yes, sir, and the video of the plaintiff falling in PUBLIX, and I think that is sufficient.
Didn't your client describe the nature of her injuries in the deposition, and weren't the nature of the injuries that she described consistent with her description of the fall?
Yeah, yes.
In other words, the fall that was depicted in the video or the still photos really was somewhat inconsistent with the injuries that she was describing, right?
Well, I think that becomes an issue for the experts, the doctors to deal with. Is
Well,
the way
see,
it's-
one of the problems here is that in these kinds of proceedings, they're evidentiary. And so a trial judge can actually take a case away from a jury and do fact-finding. I mean, a trial judge is charged with the responsibility to do fact-finding. It's a mini trial before a trial. And apparently the trial judge, made a decision that your client's motives, were not exactly pure. I mean, it's reasonable to come to that conclusion, isn't it? I mean, isn't that a conclusion that you could come to when she's describing in detail a type of fall that would be consistent with the type of injuries that she alleges she had?
I could see this if there had been some time for reflection in here, but the record evidence is that she fell. She came into the store to get some Tide. She fell. She immediately reported it to the store manager, and she immediately, that very night, reported that she had fallen onto her back. Now,
So the record is not clear on. She didn't immediately report it to the store manager. One of the employees ran and got the store manager, and the store manager came back to her and got her in the checkout. That's what the record shows, not that she went and reported it.
I'll defer to your...
But what you're saying is her description, the first description she gave was the same description she gave in deposition, so arguably she had no time to fabricate.
Correct, Your Honor. And if she came in to fall at Publix and to make a claim that night, why didn't she fall onto her back? Or why didn't she fall forward?
Why weren't the doctors called?
Report that?
Why weren't the doctors called to testify that could have probably helped your client's claim just a little bit? I mean, if the doctors presented testimony that, well, regardless of the version of events, this is a type of injury that is caused by that type of fall, regardless of whether she fell on her back or some other part of her body. I mean, it seems to me like there's a lack of evidence here, and the doctors could have probably helped you a little bit.
I believe that that's Publix's burden to prove that this change of version of how the fall occurred would have made a difference.
Well, no, but I mean, you're facing a motion to dismiss, and the trial court is trying to determine whether this is a false claim and whether it's been fabricated, and your client has different stories here, and maybe she just lost her memory and really can't remember, but the doctor certainly could have helped you with that, I would think. But you didn't call him.
That is correct, Your Honor, because of the Jacob versus Henderson case, it talks about the auto accident collision situation where if you have 9 people saying the accident occurred one way and one person saying that the accident occurred another way, does that mean that 10th?
I know, but we're talking, when the trial court is trying to determine whether this is a claim of fraud or whether this is a fraudulent claim, I mean, it would seem to me that the doctors could have probably helped you on. That's different than the scenario about causation and how the accident happened and that sort of thing. It seems to me like the issues are a little bit different there.
Well, it was more or less a strategy call because I thought the Publix would have the burden of proving that the different version of the accident would have made some sort of a difference. I have 6.5 minutes left. I'll just reserve.
Counsel, regardless of how this comes out, I want you to know we admire a lawyer that will take a tough case, and I think you realize you've got a tough case here.
I do realize.
Appreciate your presence.
And I appreciate your presence.
Thank you. Mr. Young, is it?
That's correct, Your Honor.
I don't have any questions for you.
I don't have any questions either. You're entitled to 20 minutes if you want to use it.
I was going to throw up based on the prior rulings that you made about quit while you're ahead. If that's the case, then by all means I'll concede the time. Thank you, sir.
I guess not.
Okay.